So thank you everyone for joining us today. We're happy to have you here. I know there are going to be some people trickling in because there are other programs happening right now around the ABA. But I want to welcome everyone to our program. I'm really taking stock to what's happened a year after Roe. And I'm really excited to have this amazing group of panelists with us. And we're going to kick off this presentation by having them introduce themselves. So we're going to just go down the line, and we're going to actually start with one of our participants who's joining us from New York. And we're going to invite all our panelists to tell us who they are, who they work for, but most importantly, why they do this work. So I'm going to start off with Rabia.
Hi, everyone. My name is Rabia Muqaddam. I use she, her pronouns. I'm a senior staff attorney at the Center for Reproductive Rights based in New York. And I do this work because I think abortion is essential for people's dignity and autonomy. And I want to be part of the fight to build a bigger, better right to have bodily autonomy. Thanks.
Welcome, Rabia. Next, I'm going to turn it over to Nancy.
Can everyone hear me okay? Or do I need to get closer? Okay, great. My name is Nancy Cardenas Peña. I am the campaign director for the Abortion on Our Own Terms campaign. I had a great deal of time working with the National Latina Institute for Reproductive Justice. I was born and raised in the Rio Grande Valley, so my extensive history of organizing and policy and change has been how do border communities get access to reproductive health care amidst a lot of immigration restrictions and documentation status. So really excited to talk about that and talk about all of the things that have happened since the fall of Roe and get more into that. Thank you so much.
Great. I am Natalie Hanlon-Lay. I am the Chief Deputy Attorney Attorney General here in Colorado, working with Colorado's Attorney General Phil Weiser. A.G. Weiser was elected in 2018 and took office in 2019, and it's been a wild ride ever since then. I feel really privileged. I was able to take a life pivot to take on this role, supporting him and really getting the chance to work on these issues at the state level, which is where so much activity is happening, and to be able to do my part. So really grateful for that.
Hi, I'm Sharice Scott, CEO and founder of Sister Reach in Memphis, Tennessee, and also in Chicago, Illinois. And we're a reproductive and sexual justice organization in both states. And I am in this work, I came to this work as a client. And I think it's really important to center the lived experiences and the systemic issues that impact the reasons why Black women and pregnant capable folks need abortion care in the first place. And so a lot of our work has been to humanize the individuals. They're not statistics, they are people, people with real lives and situations that oftentimes mean that they need to rely on abortion care. And so in a post-Roe society, it's really important for us to continue to lift that up and to support folks within some of those systemic issues to make sure that they can lead healthy lives and raise healthy families. So glad to be here.
Welcome to all. And again, my name is Araceli Munoz. My pronouns are she, her, hers, ella, and I serve on the CSRJ Council, which is the ABA Section for Civil Rights and Social Justice, and co-chair our Rights of Women's Committee. So I'm very excited to welcome everyone here with us today. And full disclosure, I work with Rabia, so I'm really excited to have one of my colleagues on this panel. And we're at the Center for Reproductive Rights, which is a global reproductive human rights organization. And we get to work with amazing partners like those you see on the dais today. So a lot has happened a year after Dobbs. 14 states have banned abortion. We have 13 states that have statutes that now criminalize healthcare providers who provide abortion care, with some having penalties that include up to life in prison and fines as much as $100,000. So it has really changed the landscape. Today, 68% of OBGYNs reported that after Dobbs, their ability to provide and manage pregnancies and the pregnancy outcomes of their patients has diminished precipitously. A third saying that their ability to practice within the accepted standard of care has completely deteriorated. And if that doesn't alarm you, I'm not sure what else will. There is some hope. I also don't want to be completely doom and gloom that also within that year, we had the 2022 midterm elections in which 4 states, Kansas, Kentucky, Michigan, for example, we saw resounding victories upholding access to abortion care. So there are some beacons of light out there. But I think it might be important, and Fabio, you can help me with this and help us with this, is really give us what is the litigation landscape right now in the federal courts when it comes to abortion rights.
Sure. Well, I guess I'll start with the fact that the Dobbs decision purported to do a couple of things, among others. One is to eliminate the controversy of abortion from the federal courts, and second, to return the issue of abortion to the states and their elected representatives. And as many amici and the plaintiffs told the court, that was an extremely unlikely thing to happen, and rather it would just shift the way that people on the ground were experiencing that controversy and dispute. And it would harm, a tremendous amount of people who will be denied their bodily autonomy and equality. That has proven to be correct. Federal courts continue to see a lot of litigation around abortion. Unfortunately, because there is no longer a federal right to abortion, a number of cases that were blocking total bans couldn't move forward. So we've lost a claim that we have relied on from a litigation perspective for many years. On the other hand, what we know about people who oppose abortion and the organizations who are committed to continuing to restrict abortion, their goal is to eliminate abortion nationwide. And so they are continuing to use the federal courts as a tool to do that and to come after abortion access where it remains and even where it's protected. So that's manifested in a couple of ways. One is around medication abortion. Medication abortion is an extraordinarily safe and effective regimen for managing an abortion early in pregnancy. It is primarily done with 2 medications in the US. The first one is called mifepristone. It was approved by the FDA in 2000. Mifepristone has a safety profile less risky than Tylenol. It's comparable to Advil, penicillin, and a whole host of other things. However, the Alliance Defending Freedom is representing plaintiffs in a case in the federal court in Amarillo, Texas, seeking to eliminate the FDA approval for that drug nationwide. This case has resulted in an array of other federal litigations, both seeking to eliminate access to mifepristone and cases that have come up seeking to protect access to mifepristone in states where it's protected. So those controversies continue to be ongoing. And there was a decision in the trial court in the Texas case and in the Fifth Circuit, either entirely eliminating mifepristone or reinstating outdated and burdensome restrictions. Currently, the Texas order is under a stay by the Supreme Court. But undoubtedly, given the cases that have proliferated, the issue of medication abortion and mifepristone's safety and effectiveness is likely moving through the federal courts at a rapid speed. The other area that has been another source of controversy around abortion in federal courts is cases related to EMTALA. EMTALA is a statute that protects access to emergency care at emergency departments. As many of you have likely heard, in the post-Dobbs era, people experiencing extreme threats to their health are also being denied abortion care, like the thousands of others who are unable to get access to abortion care already. The result has been some pretty extreme negative health outcomes. And the Biden-Harris administration issued some guidance reminding hospitals that even in states where there are abortion bans, they're required to comply with this federal law. And then there are some opposing decisions that came up in this context. A Texas court enjoined that non-binding guidance. On the other hand, DOJ was able to get an injunction in Idaho asserting that a total ban on abortion without an exception was contrary and inconsistent with EMTALA. And then I would say another category of this, which we're just starting to see, are cases that raise issues having to do with travel. So we now have some litigations that have been filed in Idaho and Alabama that raise the federal right to travel. And that is another area I expect to see continued federal litigation.
So we're seeing different type of action out the federal level. What are we seeing at the state level? And I don't know if Rabia and Natalie, you want to jump in. I know, Natalie, given your role, you may also have some thoughts on that.
Great. I'm glad to jump in a little bit, even though a lot of the litigation work that we've done actually has been in federal court, even though we are acting as a state. I'll kind of pick up where Rabia left off, which was the case in Idaho, which, again, it's an interesting place being in a state where, thankfully, abortion is available here. And so how we help and support folks in states where there are not attorneys general that are being able to, where the laws are not as favorable and where there aren't attorneys general who are going to make decisions. And Idaho's a really good example where earlier this week, together with other states, we filed a brief, and I note A.G. Rosenblum, who's one of our allies in Oregon, with many of the amicus briefs and letters and things that we as attorneys general are doing. We all filed an amicus about the travel issue based on the interpretation of the Idaho Attorney General's view of the law and the restrictions that made for both minors being able to travel and then the consequences for providers being able to tell people about the option to travel. And so that's one of the perspectives. Again, we are just starting to see litigation there as we see, for example, that was spurred by this very aggressive interpretation from the Attorney General, and then we chimed in to be able to provide support on behalf of the organizations that filed the legal actions there. I'll note a couple of what I call as sort of the other ways we're seeing the reproductive rights issues and abortion issues come up, which are different. As Rabia noted, we've had a flip after Dobbs where we aren't fighting ban legislations, but there are other types and places where we are definitely seeing the law being chipped away. And I can give you two examples that we're litigating here in Colorado. One is litigation that comes out of a law that was passed during our last legislative session dealing with medication abortion reversal, and a law that said that was a per se not an acceptable practice unless the medical boards, the nursing board, and the pharmacy board all found that it was. And so we are engaged in litigation that had a preliminary injunction. There was also a claim against the Attorney General trying to stop. There had been a provision about crisis pregnancy centers and saying that they can't mislead people. And again, we felt like we actually already had that authority with our Consumer Protection Act to be able to stop that under state law. We were able to avoid a preliminary injunction, but that litigation is ongoing. And then the other one is, which is really unsettling, and literally right before I came to this panel, I was on a call with the original legislator who is now a congresswoman who founded the Bubble Bill, which is the Hill case that went to the U.S. Supreme Court like 30 years ago, which provided at that time the U.S. Supreme Court allowed that there could be an 8-foot bubble around, that's what Colorado's law provides, around someone who is accessing health care services, not restricted to abortion services, to prevent that in-your-face harassment. We are now defending a challenge in federal court to the Bubble Bill, even though the Supreme Court found this exact law to be constitutional. And as some may, again, there was a lot in the Dobbs decision, but there is a particular footnote in the Dobbs decision where Alito says, and by the way, that Hill case is wrong too. And they are clearly trying to go for the Hill case. And so that's the kind of stuff that, again, is new things that we all thought that was settled law from the Supreme Court, that we weren't going to be revisiting that litigation, and here we are.
And I'm glad that you raised the complexity even for your state that is supportive of reproductive health care and access to such care. So even if you are in one of those states, you are still having to deal with this litigation to protect your citizens as you have determined best. Rabia, anything else you can share with us about this litigation landscape at the state level?
Sure. So As we all know, there are 50 states, 50 state constitutions, and the state constitutions can protect fundamental rights to a greater degree than the federal core. So quite a number of cases have been filed to seek state constitutional guarantees. We have had some success in doing that. There are states that have had a state constitutional right to abortion for a long time, such as Kansas and Montana, many other states. We received a decision in our Oklahoma cases articulating a right to life-preserving abortions that doesn't go nearly far enough, but at a minimum makes clear that doctors don't have to wait until an active medical emergency if a patient is facing a life-threatening risk. And we hope to achieve a similar guarantee in Texas in a case the center filed on behalf of 13 individuals who were denied medically necessary abortions. And other cases are going on around the country in order to expand and articulate state constitutional rights to bodily autonomy, abortion. And many of these state constitutions are actually extraordinarily broad. I'll use Oklahoma as an example because that's a state where I've worked extensively, and their constitution has both a substantive due process clause, just like the federal constitution, but then it has something called an inherent rights clause, or what professors call Lockean clauses or natural rights clauses or what have you. But they're affirmative grants, a right to life, right to liberty, pursuit of happiness. And so we think a number of these states that have these incredibly broad constitutions, at minimum, need to protect a patient's life, but really should protect a broader right to bodily autonomy, even though it was contemplated under Roe. So considerable litigation continues to go on in the state courts under state constitutions.
So I want to pivot a little bit because we've really gotten a good sense of what's happening in the courts, both in the state and federal level. This past legislative term, over 800 bills went through state legislatures related to access to abortion and other critical reproductive health care, with the vast majority seeking to, again, end or restrict access to abortion and reproductive health care. Over 800 bills. So Nancy, can you're on the ground in Texas, in one of those states that just loves introducing these bills. Can you get us started in this conversation and locating us, what is the state legislative landscape right now in terms of policy?
Yeah, absolutely. And I love talking about Texas, which, such a great question. I will start off by saying that I am not an attorney, so please offer me grace and patience throughout this conversation, but I'm hoping to also learn a lot from you all. I think the legislative landscape looked a bit different from what it usually has been, especially after the Dobbs case. And I think that a lot of folks had this sort of thinking that, well, what else could the state of Texas do to restrict access to healthcare, predominantly reproductive healthcare? And I'd like to say that there are so many things the state of Texas can do because there's a lot of creativity when it comes to restricting people's access to healthcare. And the most notable thing that we saw come out of the legislative session, and when I say come out, is presented because it did not get passed, is prosecutorial discretion, where even though we were working really, really, really hard with localities to sort of have DAs make these proclamations that they wouldn't enforce the violations of the existing abortion laws that Texas had, we had the state legislature basically say, you know what, we're going to take away the power of district attorneys, potentially remove them from office, fine them for all of the violations or statements that they make in regards to not enforcing abortion laws. And so we definitely included a lot of district attorneys, a lot of local attorneys, and to sort of help us fight against prosecutorial discretion. I don't think it's the last time we're going to see something like that. So I think this is something that the state of Texas is focusing, but as you all have probably heard, the main focus of the legislative session that we had was restricting trans youth health care. And so it always goes back to that, statement of it's about restricting bodily autonomy. and reproductive health care and restricting abortion access was just a stepping stone to a lot of different other areas that the state is now enforcing and mandating and so forth and so forth. So we definitely saw a lot of that, and we also saw a lot of anti-immigration legislation and funding that got passed. And I can explain a little bit more about that, but I think that in this room it should suffice where I say that it is preposterous that a state government is enforcing federal immigration matters at the border and continues to do so to this very day. And I don't mean just enforcing, I mean it is actively killing people who are trying to get into this country. And so many different conversations about reproductive health care around that. But I think to answer Araceli's question, there is definitely still a lot of wiggle room for states to act when it comes to restricting reproductive health care. And the other part is criminalizing people who are seeking reproductive health care.
Well, Charisse, you're kind of in an interesting place with your organization. You are in Memphis, Tennessee, where, again, you're seeing a lot of the same type of legislation and rhetoric, but you also have a footprint in Illinois. What do you see as right now the state policy landscape?
So there's several things that are happening, and a lot of what Nancy lifted up as well. We're definitely seeing an uptick in anti-abortion clinics or crisis pregnancy centers across the South, but also in the Midwest. Tennessee has lost access to Title X resources due to prohibiting referrals for gender-affirming care and abortion care access. There's also been a prohibition of reproductive justice, health, or rights groups like Sister Reach in Tennessee from being able to access public schools if we wanted to teach comprehensive reproductive and sexual health education, which for us is interventive. It's intervention and it's prevention. And I thought that it would be the answer, right, for us to be able to reason together, but it just seems to, I think that the goal of the Tennessee legislature is to be in full control over people's knowledge about their own bodies, their ability to be self-determining and have agency, and while also restricting access due to religious directives, which is something for me. And I'm not a lawyer either. Once upon a time, I was a paralegal. That's as close as I got. But I think for us, it's been really interesting to see we are in the Bible Belt. The buckle of the Bible Belt, we say, is what Memphis is. And so a lot of our work has been working in interfaith communities, doing education around religious freedom, religious autonomy, which is what we like to call it, because I think it's really important to think about, the Bible Belt means that it's super Christian heavy, but the entire state does not reflect a Christian understanding or belief system. And so then to try to enforce the Bible as the state book, and it has been one of the things that has happened, but also empowering pharmacists to have, to be kind of emboldened around religious directives to push back on white women very specifically from being able to access birth control, right? So I think that our work with reproductive justice is to kind of peel the layers of the onion back to kind of get to the root of the why behind a lot of this. And as far as we're concerned, it's definitely been about forcing white women to give birth and controlling women of color and pregnant capable people's bodies from having more children, right? So that is part of that. Also abject poverty. As a result of COVID-19. And then we have a lot of gentrification happening across the South, which is causing housing displacement of low-income and working-class people. A lot of what Nancy lifted up around anti-trans laws, we're seeing that. Of course, there was the big stink about the drag shows and Lizzo coming to Tennessee and, really trying to lift some awareness around all of that. But also trans athlete bills and bathroom bills. And then, of course, there was a restriction where youth could not cross state lines to get gender-affirming care, but that has been rolled back so the young people do have access to gender-affirming care in the state. Also, anti-LGBT bills prohibiting education and information in the public school system, even around pronoun usage, right? Emboldening not only young people to bully, but administration as well, right? So we are doing a lot of cultural humility work of trying to kind of lift this up. This is, especially in Black communities where it's kind of taboo to talk about sex anyway, but then even more so taboo to talk about sex kind of across the queer dynamic. Anti-CRT, we know that that's a nationwide issue. And of course, well, I think that's where I'll stop. So, so we're seeing, this happening across. So these are this kind of, there are over 500 bills, I think, were filed in Tennessee this legislative session. And around one or, the combination of anti-LGBT and or anti-abortion access bills.
Well, you've given us a lot to unpack during this conversation, so I'm going to get back to some of those things that you raised, because you put out there a lot of things that we want to unpack. And I want to go back to something you said, and Natalie, if you could pick up on something that Charisse raised when she talked about, even in the Midwest, having a footprint in Illinois, which is seen as a progressive state that really embraces access to reproductive health care. Your state, where you also are in that position. What are you seeing as some of the state policy landscape from the other side?
Yeah, and we still have both. We just have right now we have a majority of Democrats in both houses, so the laws that try to restrict abortion haven't gone anywhere, but we had a ballot initiative 2 years ago. I expect that we will have a ballot initiative this next go round as, again, folks are trying any way that they can. But I think we have thought on the other side, you get the question, well, what can we try to do to protect choice and to protect women's reproductive freedom and women's health? And so one of the things that I am really grateful for is that right before the Dobbs decision came out, Colorado passed the Reproductive Health Equity Act, which before we had previously years ago, they had gotten rid of the historical ban on abortion. The pre-Roe ban had been repealed. But really the reliance for the right was on Roe until last year. And so our state legislature, seeing what was coming, passed the Reproductive Health Equity Act, which really gives us a basis to be able to make sure and effectively enforce if we ever need to. We haven't actually, the Attorney General has enforcement authority as others, if there are restrictions that are out there. And again, we haven't seen that. We have thought of scenarios that we worry about that I don't really want to talk about because I don't want to give anybody ideas of things that they may try to do to get around that. But I feel good that that was one positive thing they were going to be able to do. This last session, as I mentioned, I think legislators have tried to think of other ideas, and one of them was this provision that we're now litigating that deals with the issue of what doctors can say about medication abortion reversal, and the other being these pregnancy crisis centers. And, again, I think it is hard because it is, we want to be able to do things that are helpful, and I anticipate every single law that relates to abortion that our Democratic legislature passes, I'm going to be defending. And some are easier to defend than others. It's sort of like with the bubble bill, the question comes, should we change it? And I'm like, no, let's not change a bill a law that the Supreme Court has already found, even though we think it's a different Supreme Court and we could be risking more. I want to be careful, even though we might say, well, we should have a 10-foot bubble or a 20-foot bubble. Why don't we do more? By doing that, we potentially risk everything that we've fought to have and that we rely on here in Colorado.
So I want, Robbie, your help in helping to complete this landscape, and if you could shed some light on what's happening at the federal level in terms of federal policy.
Well, a lot of gridlock, frankly, with the divided government, a lot of policy objectives I think that we might hope to pass in the future, just don't have potential favorable outcomes. But I do want to mention that the center and many other organizations have long worked to pass the Women's Health Protection Act. And that bill would restore but expand a right to reproductive health care generally. It would talk about parental care and the care that people need across their spectrum of reproductive choice. That bill, we hope one day will be the basis for a new way of thinking about reproductive autonomy. But for now, there aren't any sort of statutory things coming to the fore, with the exception of something called the Pregnant Workers Fairness Act. And I do want to highlight that as a major success, which seeks to end certain types of pregnancy discrimination in the workplace. However, despite the inability to advance statutory protections, I think it's important to note the efforts that the Biden-Harris administration has made through agencies to protect access to reproductive health care where they can. There are limited options for the administration. However, we have seen, an emphasis on EMTALA and the protections for emergency care under federal law. The government has put a robust defense of the FDA's approval of mifepristone in the case that I mentioned earlier. And the administration is continuing to enforce EMTALA against hospitals, including recently in Missouri and Kansas, against 2 hospitals that turned away a patient who was experiencing premature rupture of membranes. So we are seeing quite a lot of support from the administration to the degree that they can act. But in this new post-Dobbs landscapes, there are limited options on the federal level. And I think this era is so unprecedented for a number of reasons. But one of them, I think, is what happens when the court starts to overturn longstanding precedent. There's a deterioration in adherence to the law. And so we're starting to see red states not just implement abortion bans, but to try and do things that we've never seen before, such as attempting to criminalize people for their movement to get abortion services even when they're illegal. And those efforts didn't really pass, except in Idaho with respect to minors this session. But I think we can continue to expect to see hostile attempts to push the law beyond its traditional borders. And I think the administration will continue to reject those efforts, but they have limited means to do so.
So I want to pick on something that all of you've talked about, which is, now that we've got this legal landscape, this court landscape, is what does accessing this care actually look like for people who actually need it, birthing people who actually need it. And so, Sharice, what does access to reproductive health care look like for birthing people in Tennessee?
Scarce, right? Folks are leaving the state for abortion care, but are also really afraid to even say that they are pregnant because of this kind of tracking. So a lot of what Rabia lifted up, thinking about digital surveillance, internet surveillance, even trying to access emergency contraception over the counter in some pharmacies. First of all, the emergency contraception is locked up. Or it's out of reach. It's not necessarily, just you being able to get it off the counter, but it's also that you're having to scan your ID to show that you are old enough to have this, right? So we're really concerned about what digital surveillance, with our IDs is going to look like as well. One of the reasons that we moved to Illinois and expanded a second location was because I didn't know what to expect. I wanted to be able to continue to run this organization that's doing really great work in the state, but I also wanted to be able to protect myself and to protect my staff in the event that our work would become criminalized in any way, shape, or form. Right now, we're prohibited in going into the school system because we advocate for abortion care, because we have a practical support fund that gives people access to housing and transportation and child care and food if they are trying to access abortion care wherever it is that they're trying to go. It's really hard for folks to afford to leave the state, and so folks are forced to have babies that they may not want, or it may be unsafe for them to have. I want to lift up folks who are victims of intimate partner violence, who oftentimes are held captive, right, by their spouse by being pregnant and do not necessarily have the resources to leave and or will not leave their other children for safety. So we're seeing, you know, those pieces as well. But then, I also think that the gender affirming care piece has also kind of just rolled into this, right? Where parents are terrified, not just about what it looks like for their child to be able to access care, patient-centered care, patient-led care, where they have a compassionate environment, but what this might look like for their parental rights moving forward. So we are already anticipating that parental rights would possibly be threatened with folks in the next legislative, sessions, maybe over the next couple years or so. We already saw that with the fetal assault law of 2014 to 2016 that criminalized pregnant women for using opioids and then expanded that to any drug, right? And then took their children. So that's still what's kind of occurring in our state. As well. So folks it scares people are calling, they're needing help, they don't really know what to do, but even accessing, like I said earlier, about accessing birth control, and we're talking about birth control where your doctor already gave you a refill for the year and you're still not able to access your birth control, and or you are a woman or person of color and an IUD or intrauterine device is being forced on you because it has been you're categorized as someone who's having too many babies. But that is predominantly women of color, girls of color, and pregnant capable folks in that age range. So we're seeing it's eugenics all over again in Tennessee. I think something else to lift up is, along with the fetal assault law, what came out of that was the need for the anti-sterilization bill that we helped to inform, passed by Senator Akbari, that prohibited the carceral system from offering people a vasectomy or an IUD for reduced jail time, right? And there's 97 counties in Tennessee, and 91 of those counties were participating in that. So you leave jail, you go to a clinic for voluntary birth control or voluntary sterilization, and then you are released into population, is what's happening in the South. Right, and so these are some of the things that I think that that aren't fully on our radar, kind of in this kind of mainstream way that we're moving in this work. But these are issues that are happening on the peripheral that we need to really put in the center of the lens, because it's all out war on bodily autonomy and forced birth for those who are regarded as valuable and worthy to birth, right? Is something that we're lifting up. So it's so definitely anti-racism, anti-Black racism, anti-brown folks racism, anti-immigrant racism, including those with. In our state, we're also seeing folks who are undocumented, who also have language barriers, having to, deal with the emergency room system or urgent care system, and maybe there isn't adequate staff to make sure that folks have somebody who might be Spanish speaking, who could support someone who is in need of care, and for undocumented folks being offered an IUD before they're even offered anything else, right? If that person is pregnant. So it's a lot of stuff, and it's a whole lot of moving parts, but I think that that's intentional, like that's on purpose for there to be a lot of moving parts and for us to kind of be swept up in it all so that we can't focus on, these intersections of the ways that people's bodily autonomy is being impacted.
That's a lot to digest. But I'm going to ask the question, Nancy, what does it look like on the border? I mean, you touched on it a little bit earlier about the nexus between immigration and access to care.
Not great is my summary of the answer to that question, but I'll elaborate. And I think folks also had this perception that Dobbs came up and all of that, and it didn't happen overnight. We've had a long history of lack of access to reproductive health care that was further emboldened by SB 8, SB 4, all of these anti-abortion measures. And so in community areas, in border communities like the Rio Grande Valley, for example, there was only one abortion clinic left in a region of over 1 million people. And it was already difficult enough. And it was difficult enough because the state creates these additional barriers for folks. And so 100 miles into the state of Texas, there are things called border checkpoints, and they are already inside the United States, but they are 100 miles in, that ask people about their documentation status. And if you are someone who is undocumented, you cannot leave border communities at all. And so when you're talking about the Rio Grande Valley, these border checkpoints 100 miles in completely surround the Rio Grande Valley. So it wasn't a conversation that we were having with people of, oh, well, just travel to New Mexico for healthcare, just travel to Colorado for healthcare and for abortion access. Folks could not travel. And for a lot of variety of different, very valid reasons, people couldn't travel at all to other states. But primarily, that's what we were seeing on the ground, is because of documentation status and because of internal immigration checkpoints 100 miles in, people could not leave border communities to access abortion care. There is no in-clinic abortion care left in the state of Texas, none. The only care that is left is potentially medication abortion. And even though it isn't technically illegal to criminalize someone who undergoes medication abortion, we are encountering lots of situations where people are still criminalized, and not specifically under anti-abortion statutes, but a variety of other different things, like it could be child endangerment, it could be like bodily harm, all of these different things. We recently had a case in the Rio Grande Valley where someone was criminalized for terminating their pregnancy. They were given a $500,000 bond. They were charged with first-degree murder. So these were the kind of things that we had to work with, is all of these different conversations where we had opposition saying, well, that's technically not under SB 8, so how is that our fault? But these are very intentional consequences of passing anti-abortion legislation, is that people who are able to get pregnant get enveloped into criminalization. And the intersection of all of that is that we have multiple agents of enforcement. We have immigration, we have DPS, we have police, we have ICE. And so all of these different entities were working together to prevent people from living healthy and fulfilling lives. Another tenet of reproductive justice is that people are able to have children and raise them in good environments. And that's is something that applies very much to the Rio Grande Valley, where we had people who were being separated. We had people who were being sent into deportation proceedings. We had people who were scared to go to the doctor. And so we had to talk about all of these different, very complicated things. And on top of that, we had people who were trying to come into this country for a variety of different valid reasons, and who were remaining pregnant in order to try to get some sort of status in the United States, and for your entire reproductive destiny to be around your access to getting some sort of visa in the United States is pretty horrifying, that the state is continuously imposing all of these different rules. So of course we had to sort of go back to the drawing board on how we were going to be able to answer all of these different segments. And it was creating accompaniment systems, it was creating buddy systems, it was talking to people about information and education and their rights and so forth, but also being extremely creative. I mean, the criminalization aspect of the case where someone was charged with, first-degree murder, we mobilized pretty quickly. We got so much media attention. We had people who were a lot higher up do statements about it, and they were released and the charges were dropped. But this isn't going to be the last time something like that happens. And so this is sort of the question that we're at, where there is no in-clinic access to abortion care. There's only medication abortion, and even that is extremely criminalized in states where there are no laws on the book that criminalize the person itself for self-managing.
So I want to go back, and Sharice, I want your help on this, to something you raised, Nancy, reproductive justice. I think we throw around reproductive rights, reproductive justice, reproductive health, and as if they all mean the same thing. Can you locate us in what these three very distinct terms mean?
Absolutely. So reproductive justice was a term that was coined in Chicago in 1994 by 12 Black women and created to center the lived experiences of Black women around issues of reproductive and sexual health. The framework is grounded in Black feminist theory and human rights, and central to reproductive justice theory is the universal human right to dignity, self-determination, and autonomy. The framework centers people whose liberty has been violated and whose social and economic well-being and culture has been deliberately ignored. And then it seeks to liberate and emancipate vulnerable populations from all forms of reproductive and sexual oppression. I think what's important about the framework is that it challenges us to expand our analysis beyond abortion access, to center all of the issues, like what we're hearing on this panel today, that impact people's ability to thrive, to live in abundance. Let's go there. And so if we think about, so we talked about reproductive health, which is individual service delivery, social services, and then reproductive rights, which is the public policy, legal advocacy, and U.S. Constitution components of the ways that the work operates. And then reproductive justice is that movement building component using human rights standards for accountability and applying intersectionality, which is also thinking about the ways that multiple oppressions operate in the lives of people. Or a person, right? And then as an inherent practice, centering the voices and the leadership and experiences of those who are most impacted. We organize with reproductive justice. We share our stories. We tell our stories, right, with this particular framework. However, all are important, right? One doesn't cancel out the other, and we've needed all three of these really important elements, right, of organizing and frameworks in order to move liberation forward for the whole. And so that also includes, though this is, a framework that was, reproductive justice was coined and centered for Black women and women of color and folks of color, it absolutely includes white women, right, and white pregnant capable people, and so we find ourselves, also, right, asking, and I do, in reproductive justice trainings that we do across the country, what are experiences that white women are facing, and we really need to hear those experiences so that all can be humanized across the board. Historical violence, sexual violence, cultural violence, gender violence, all of those elements of the work. So that's kind of it in a nutshell. And then our sistren across folks of color have adopted and adapted and expanded reproductive justice to be culturally centered in the ways that make sense for their communities. Right, our indigenous communities, our Latinx and Hispanic communities, our Asian and Pacific Islander communities as well.
So before I turn to my next question, I'm going to just do a quick commercial break. There is someone walking around with white cards. If you'd like to ask questions of the panel, they will be going around and we'll be collecting them so that you will have an opportunity to have your question asked. And so while that's being passed around or walked around, I want to ask a question about providers and what that is looking like. What is it looking like for providers to give care? That statistic we noted, a third feel that they can't give quality care, that their ability to give care has deteriorated. So Rabia, Natalie, what can you tell us, from your perspectives, what is this looking like? I know, Sharice, you alluded to it, talking about your organization, but if you can also share with us, Rabia and Natalie, what it's looking like for our providers.
Well, post-Dobbs unleashed some of the most complex legal questions, but those questions manifested in widespread and pervasive fear. More than anything else, the wave of criminalization of providers caused quite a number of ills. But for providers like the clinics that we represent, the center we represent, independent abortion providers, among others, they were grappling with how to move to other states, how to continue to provide care if it was possible, how to protect their staff and their clinicians, how to deal with patients traveling hundreds of miles from other states. That has always been true, that Roe was never a reality for many people in the South, and so people always traveled. But now they were traveling from states where there was this wave of criminalization. And that fear affected particularly those providers who perhaps didn't work in an abortion clinic, who were hospitalists, who were OBGYNs, who care for people who have miscarriages, who care for people with fetal diagnoses. And so what has happened is widespread, really, elimination of reproductive health care across huge swaths of the country. I'll take Idaho as an example. I think about over half of the state's maternal fetal medicine specialists have left the state because they were terrified of being criminalized for providing the care that they were trained to provide. So the maternal and parental health system in that entire state is collapsing because of this fear of criminalization. And that fear is not unfounded. As Natalie was talking about, we have attorneys general, including the Attorney General of Idaho, but including the Attorney General of Texas, Florida, making really threats to extend the law beyond any reasonable understanding, to come after people traveling, to come after providers who are offering care to people from banned states, to come after people for referring and providing information, even though none of the laws that currently exist extend to criminalize that conduct. And so what really is happening is that climate of fear is collapsing healthcare for everyone. And all of these things exacerbate the fact that, particularly in the South, but generally in the United States, we have atrocious obstetrical care. And that is particularly true for Black women and other people of color. And so what is happening is people who already face disproportionate barriers to accessing healthcare due to structural racism, due to inequities, are being harmed all over again by an immense constriction in access to that healthcare. And the strain is being put on the remaining providers who are in states where access remains. And I'm sure that Natalie has quite a lot of experience in talking about what has happened in the states where access remains and how challenging it has been for those health systems.
Natalie, would you care to share?
Yeah, glad to share that. What's happened is we've had a huge increase in the number of people that have come here to be able to get abortion services, which then results in a longer waiting time for everybody else. And our providers, I really hearing Rabia talk really resonates with, even in a state where we have a Reproductive Health Equity Act, we have laws to protect providers, there's a lot of fear about a lot of things. And we've done a lot of listening sessions with providers to help understand those concerns. And frankly, right after the Dobbs decision came down, it was like, well, what do we do to help? And, our governor entered an executive order right out of the bat saying we want to give assurances to providers that if they provide services for someone out of state, the Colorado will not participate in investigations, that we will be, it won't affect your license and other issues. I think one of the concerns they had was if they treat someone from out of state and that another state licensing board finds that, tries to find something there, or particularly doctors that are licensed in multiple states, very concerned about an action, even if the action is legal in Colorado, then another state would find that they did an illegal action and take away their medical license. And so the governor entered an executive order. We, in our legislature, enacted an interstate shield law that protects providers from criminal, civil, licensure, and insurance consequences if they provide medication abortion in particular across state lines, and also prohibits government resources from going into these investigations. But I would say that even here, it is a capacity issue, but it is still a fear issue, that it is much more complicated to be able to provide health care to patients in a patient-centered way based on what is going on outside our borders.
And so I just want to ask Nancy one last question, because I know, Sharice, you touched upon it. But Nancy, what is it looking like for your organization as well? Are you guys feeling the pressure? Because you're not a provider, but you're still helping people. And under so much of this legislation, as Sharice said, you don't know where you stand for doing the work that you've always done.
So I think that's a really, really great question. And I think it goes down to sort of the stigma behind medication abortion, and it's definitely sort of like a culture shift in different steps, where we still have sometimes people who are confused or concerned about medication abortion, and we have this narrative sometimes where people assume that if we're choosing medication abortion, it means that we were really desperate and that was our only option. And that's just not the case. Sure, we can look at states where there is no in-clinic abortion care and realize that medication abortion or self-managing is the only answer. But there are plenty of other reasons why people prefer to self-manage. And I prefer to self-manage my own abortion because I liked being that autonomous human being who had the power to decide what happens. I wanted that privacy. I wanted that element. And that's what works best for me. And so I think we are still going around having these conversations around that culture shift, and having conversations also about Latinx communities and how they feel about abortion. And of course, the pretty obvious answer should be is that Latinx communities don't belong in a box. There are so many different communities that classify under Latinx, and it's not just a monolith. And so, you know, in conversations and having that culture shift with people, we've realized that, you know, everyone loves someone who's had an abortion. If we know someone personally, we know that we're going to support them. We know we want what's best for them, and that includes supporting them through an abortion procedure. And so a lot of the conversation is that, and we're also running into how do we get that information into directly impacted communities? How do we manage to get that information to those communities in a secure way where we protect ourselves and we protect the people who are receiving that information? And so that's kind of where we are at now. And I'll say, after working, you know, at the legislature for so long and being so reactive to everything that Kim Paxton was doing, it's so nice to be able to sort of brainstorm and think about all of these different ways that we can reach out to people and truly create a world where we're advocating for all reproductive health care options. And we're not just limiting ourselves to, well, you know, people can still get pills wherever they are. No, that's not the point. We should still advocate for all of the options because our reproductive health care shouldn't be in a box.
So we've had a lot of this conversation's been challenging and difficult and a bit depressing, to be real. So how do we rebuild? How do we rebuild? Where do we go from here? So Robbie, I'm gonna start with you. How do we rebuild in terms of the courts?
Well, it's not going to happen overnight. I think, you know, a huge aspect of this is the composition of the courts and how much they have radically shifted. I always like to point out that Roe was a conservative majority and a strong majority. The difference between today and then is a majority of members of the court that believe that the certain substantive liberties do not exist under the 14th Amendment. So it's going to take time. It's going to take really rebuilding the judiciary to be an entity that is actually independent from political forces. But I do want to emphasize, I think, what both Charisse and Nancy talked about, which is that reproductive autonomy is not just about abortion. And one of the things that happened after Roe was a marked shift in the political discourse, in the resources allocation, in the political, the donations, everything, to a national infrastructure that included organizations like mine and away from organizations on the ground in the states. And that allowed a lot of things to go unnoticed in some ways by the mainstream political discourse, which was the fact that Roe was already no longer a reality for many Black women and people of color in the South, for rural people, and for people who otherwise lack access to resources. And so we focused very heavily on defending this right to abortion. But the right to abortion is itself a Band-Aid. What we need is a liberty interest that recognizes personal autonomy, bodily autonomy, to make decisions about healthcare, whether that's having a child in a safe environment, having the resources to build the family that you want, to not have the children that you don't want. And so when we rebuild, we need, I think, to be making legal arguments about a much broader idea of what liberty is and what substantive liberty is, of course. That also draws on human rights frameworks and makes clear that what we're talking about is personal dignity and decision-making and autonomy. And that right is woven through access to transgender medicine, access to abortion contraception. And I do want to, encourage folks to look at the website of the Alliance Defending Freedom, which is the organization that brought the medication abortion case in Amarillo. They're litigating the challenges to CPC requirements. They have a website on their, they have a page on their website that talks about family values versus the myth of individualism. And it talks about how they use the power of the law to eliminate individual freedoms. And so what we are seeing is the use of the courts to impose a very particular religious view, not everyone's religious view, but a particular religious view of families of America, and to impose that on everyone else via eliminating these, what they perceive as these individual rights. And so that's the battle that we're in now. And so I think as we rebuild, as we bring cases to articulate rights to life, rights to dignity, rights to autonomy, we need to get at that fundamental truth, which is that some of us think that the Constitution protects the individual's right to make decisions, and there is the other side that does not. And so I think we need to work together across movements. I think we need to work with our colleagues in the LGBTQ plus space, people who work in access to maternity care, access to midwifery, because we are all on the side of bodily autonomy, and the right to abortion was always a narrow slice of that. And so as we rebuild, and it looks like bringing cases under the state constitution, it looks like shifting the composition of the courts, it looks like passing favorable laws in access states and passing federal laws and continuing to percolate cases up through the courts that articulate this broader right and reassert that the Constitution fundamentally protects the individual's right to make those decisions. And I think all of that is going to take a long time. So, after Roe was enacted, anti-abortion activists had 50 years, and what they did was they chipped away. They passed a law that went a little bit further every time until they waited until the composition of the court changed sufficiently to overturn Roe. And I think we need to think in a similar way to reach people who are persuadable and to explain that this isn't about abortion. This is about an individual's right under the law to make those decisions. And I think, and as the polling shows, the vast majority of Americans support those rights, even though they are not represented in the actions of their legislatures. And so I hope that, through that, all of those efforts, but also through redirecting resources to organizations like Sister Reach, like Abortion on Your Own Terms, like all the other state advocates, because it's also going to take reform on the ground and in those state legislatures.
So I want to jump in because Charisse, you and I had this conversation during the prep, and something Rabia touched upon from Alliance Defending Freedom, this notion of white nationalism that you had raised, and how that's tackling that has to be part of the rebuilding process. Can you share a little bit more about what you were thinking? Isn't that?
Yeah, I think that's one of the largest pieces for us, and especially myself and 3 other staff of mine are clergy. And one of the things that we've been intentionally doing is trying to tackle Christian nationalism, right? So, and call it out for what it is instead of what it's being positioned to be. It's not about Christ. It's all about control. It's all about white supremacy. It's all about controlling women's bodies. And so one of the things that has been really important for us was trying to think about litigation offense rather than defense. So one of the things that we've been trying to do in Tennessee is to figure out how do we protect religious autonomy of people, right? Because I think that's, I think that's a strategy that I don't know that we're paying enough attention to. So all you amazing lawyers, I think that's something that we would like to see there be, whether it be on the state or the federal level, maybe it just wasn't a good idea on the state level. We thought it would be great on the state level because we have theological backing behind the ways that we feel around why abortion is not a sin or, not evil or not murder, why a woman's autonomy around her body is a sacred birthright. So just kind of thinking about it in that way. And because we see Christian nationalism and white nationalism, kind of the conflation of the two, as seems to be the newest strategy, this kind of moral, hijacking of, or the hijacking of morality around this particular thought process that is incomprehensive beyond stopping folks from having an abortion, but there's nothing in there about taking care of families after the baby gets here. It's nothing about ensuring that folks can eat and people have a roof over their head and all of the things that, if this is about Christianity, that does not align with the ministry of Jesus. And so, we have been, what does it look like to have religious leaders stand boldly and call that out? And say, you do not get to hijack this particular understanding of biblical text to forward or wield an agenda that harms people, but that you make provision for compassion and love, right? And centering people's ability to be self-determining, not to be forced to make decisions around what they consider to be right or wrong in their lives, but allowing them, to do that, right? Like, how do you demonstrate that versus, legislate religion, and so, what does it look like to protect religious autonomy for people as well? So that's definitely been one of the ways that we've been trying to, and we've been organizing clergy across the country for the total span of my organization, which is almost 12 years in October, trying to do just that, trying to shift culture, trying to, give people, here are tools, here are theological information, like these are stories, like this is what you can say, sermon preparation, like this is how you help people share stories in like testimony service or however in counseling, like this, it's important, like we've got to be able to shift culture and be just as unified in the ways that we are supporting, our cause, right, and our base, the way that we've seen the conservative religious right do the same thing. I think that we're just missing that. But I do think that litigation around religious autonomy is going to be that kind of cutting edge thing. And maybe we've never tried it before, but we've already tried the other stuff and it didn't work. Right? So why keep trying to do it the same way, right? So let's try something else. And even if we fail, we tried, right? And so I've been really discouraged, to be quite honest, because we've tried to partner with some national groups to try to move this litigation to protect religious autonomy in Tennessee as a test case state that could be used in other states, since Tennessee seems to be one of the states that, passes litigation that folks copy across the country, especially in the South. So, and to see what that might look like. So we're holding out hope that we will be able to do something around that. And we want to bring, those theological savvy folks along with amazing litigators together in one space to figure out how do we do this in a way that just protects human rights. And a part of human rights are religious rights. And so, at the very core, it is protecting democracy, right? And we want to make sure that the folks being able to have religious autonomy continues to be a part of that, and that nobody gets to mandate what I believe and what I don't believe, right? Where there's not just folks who are protected who are religious, but people who are non-religious also have protection. We've got to continue to make sure that space is there, because in where I live, right, it is through this kind of it's through Christian nationalism that people's rights are continuously being picked apart, whether we're talking about LGBT rights, whether now we're talking about abortion rights, whether we're talking about parental rights. It is this kind of moral narrative that continues to be driven is the reason that it's justified why people can wield this kind of negative energy and power politically.
So we've had a very robust conversation. We are running low on time, and one thing I want to make sure that we leave enough time, and we can, if we still have time after that, we can continue the conversation. But one thing I want to make sure is that each of you share with us, as we look to rebuilding and the path forward, what would be your call to action? I'm going to start with you, Nancy. What would be your call to action as we look to rebuild?
I think we're in such an interesting position because we have a lot of American countries that are making such giant strides when it comes to ensuring that people have abortion access. And so I guess I wish I could do a lot of call to actions, but one call to action that I want to make with this like tenet of hope is that whenever we do this work, we should look beyond our borders and look towards other countries that have really great examples. I mean, we started working so closely with Mexican accompaniment networks and organizations in Colombia and Argentina and Chile, and it's been so amazing learning about everything that they've done because they're in exactly the same, well, they were in exactly the same position that we were in. And so just sort of getting that hope that they have. And, you know, we're in a position where we can create what abortion access will look like, and we can dream as big as we want to. And yeah, I want to create a world where people have access to abortion care regardless of their gender, regardless of their documentation status, regardless of their income level, where abortion is completely free, as healthcare should be. And that means dreaming pretty big, and I think I'm willing to do that, and I hope others are as well.
That's a great call to action. Natalie, what would be your call to action?
Well, I guess as the lawyer, one of the two lawyers on the panel, I'll stay grounded in the law and then maybe a little bit on the personal side, which is that we need to keep fighting and think about it at the big level, but it's not one, to the point that was made earlier by Rabia, we didn't get where we were with one action, that we got there over 50 years through a lot of things that happened, and I think that everything that, again, that we do in our office, that our colleagues in other states do, the actions that are brought by various groups like the Center, by Planned Parenthood, other challenging things is really important, that we need to be thinking about it, and we need to be thinking about both the short and the long game on this. And one of the things that I would note, I'm really resonating about your religious autonomy. I want to talk more about that so I can understand it, because in my world, what I am finding, and we were counsel in the 303 creative case, which was such a hard experience for us, and I'm very convinced there's nothing more we could have done, because that Supreme Court was ready to take the action that it did, using the First Amendment and someone's First Amendment beliefs as a way to limit public accommodation. And we have similar cases that have been based on free exercise, and seeing First Amendment and free exercise being used to curtail that individual liberty it's like turning religious autonomy on its head. And so I hope, and my call to action is that we have to really be smart and thoughtful and strategic and not give up, and to watch all of these things. And then I think on the personal side, I have 2 young adult daughters in their early 20s, and it's been jarring being on this journey with them. And we did need to do everything we can to raise up the next generation to be educated about what they do, to help them. And it's hard when I hear sometimes the reaction like, "Mom, there's just so much that I'm really numb. I can't handle it." And it's like, I know you are, but you have to. Like, I'm going to be counting on you. And so thinking about how we really think, again, the long game for this, which is what I think we need to do.
Sharice, what would be your call to action?
Well, I talked about the religious litigation piece, but I think it's really important to put the hands into the, put the power in the hands of people and prepare people in the now. And so for me, that looks like intervention. That's supporting safe sex kit distribution, which is a program like we have, emergency contraception access without people having to go to the pharmacy, supporting natural family planning, but, I guess more relevant to this room, fighting for comprehensive reproductive and sexual health education in the southern states, and then making sure that it gets implemented. Illinois has, we have CSE access in Illinois, but it's not implemented. So young people still aren't learning anything, right? So we got to make sure that we have that piece, and then continue to build this pipeline for progressive patient-led care, which means how do we protect doctors and how do we protect patients, and how do we protect doctors who are working within institutions where they cannot go against the kind of institutional rules in order to provide the care that they know is necessary for their patients. And so that, for me, looks like, how do lawyers partner with, ACOG or, whomever, American Medical Association, in order to think those types of things through. So intervention and prevention, that's my call to action.
And for folks, ACOG, American College of Obstetrics and
Yes,
Gynecology.
I'm sorry. The movement of acronyms. I'm so sorry.
So, Rabia, we'll close out with your call to action. What would that be?
Well, I guess since this is an ABA event, I will make this action. But, being an attorney is a privilege. It makes me an officer of the law. Our job is not just to advocate. I mean, it is, of course, to advocate for our clients in the most zealous fashion in accordance with the law. But what we are seeing right now is an erosion of every single norm that we learned in law school. I went through my Chemerinsky book the other day and I looked at all the precedents that have been overturned over the last few years. And next year we could be looking at Chevron being overturned, among others. And so I call on lawyers everywhere to use their voice and whatever platform that you have to call out what is going on in our legal system. And our legal system has always been a broken system in many ways. But I think we need to stand up and really speak publicly to our colleagues, to our communities about this real breakdown and violation of the spirit of the Constitution and of the law. And if the Constitution does not protect these most fundamental freedoms, then what good is it? And if it doesn't prevent a court from deviating from the most foundational principles of standing or access to the courts or judicial restraint, then what good is it? And so I, call on all of us to use our platform to advocate for the law to be objective, to be the thing that we hope it to be, to fulfill the promise of it. And so I'm glad that this panel is here and that you all are here to listen to it. And I know that there are many all over the country who are ready to take up that call.
Thank you. So I want to thank my panelists, and a couple of things I just want to share with folks. This has been recorded, and so you will be able to access it, and we encourage you to share it and spread the knowledge, spread the call to action, spread the information. And I also want to invite you to join me in a round of applause for our amazing panel. Traveling wide and far and through the universe, the webverse, to be with us today. And we will be around for a few minutes, or they will be around for a few minutes. I know Rabia might be trickier for you, but they will be around if you have any questions for them. I know there were some questions, but I think in our conversation we tackled some of those. And we just want to thank you for joining us this afternoon.